Hello and welcome. I am Professor Rashmi Raman and this is Module 16, Crimes Against Humanity, Part 2 in the paper International Criminal Justice. The category of offences under the ICC, ICTY and ICTR statutes include murder. The mental element of this conduct is the intent to bring about the death of another person. It can be intentional in nature and may or may not be premeditated. That it must be planned well in advance to the act of killing is the sine qua non. However, for a murder to constitute a crime against humanity, a lesser mental element is required as established by case law. It is sufficient for the perpetrator to cause serious injury with reckless disregard for human life. In Kayishema and Ruzindana, the court held that murder constituted the following elements. 1. That it causes the death of another person, which is fairly obvious, and 2. That it is caused by a premeditated act or omission, which is not so obvious, and that it intends to cause grievous bodily harm to any other person, and therefore intends to kill the other person. In order for murder to constitute an offence of the gravitas required for it to be a crime against humanity under Article 3, Clause A of the ICTR, in addition to the above requirement, the victim must be a member of the civilian population and the act or omission must be a part of a widespread or systematic attack against the civilian population based on national, political, ethnic, racial or religious grounds. The words civilian population have a similar meaning under both Article 7 of the ICC statute as well as Article 5 of the ICTY statute. However, in these statutes, it is non-discriminatory in nature. The second part, extermination. Extermination is primarily concerned with the mass destruction of a group of individuals where the scale of destruction is larger than simply murder. Under the ICTY, the necessary elements to establish extermination are as follows: that the accused or his subordinate should participate in the killing of a certain named or described persons, that the act or omission should be unlawful and intentional, that the unlawful act or omission must be part of a widespread attack, and that the act should be against the civilian population. However, under the ICTY, the attack is based on discriminatory grounds, namely national, political, ethnic, racial or religious grounds. In Kayishema, the trial chamber laid down the essential elements of the crime of extermination, that the actor should participate in the mass killing of others or create conditions that lead to the mass killings of others through their act or omissions, that the actor should have intended the killing or should be reckless or grossly negligent as to whether his act would result in such killing, and that he should be aware of the fact that his acts or omissions form part of a widespread or systematic attack against what is the civilian population and is created on national, political, ethnic, racial or religious grounds. The elements of crimes provision under the International Criminal Court has to meet the same criteria as these two statutes. However, it does not state whether the offence has to be committed negligently or recklessly. A third crime against humanity that is common to these statutes is enslavement. The general element associated with this crime is that there should be ownership and control. Under Article 7(2)(c) of the ICC statute, enslavement means the exercise of any or all of the powers associated with the right of ownership over a person and includes the exercise of these powers for trafficking of persons, particularly women and children. The elements for enslavement are set as follows: that the perpetrator has exercised any or all of the powers attached to the right of ownership over one or more persons that include purchase, sale, lending, bartering of person or persons, depriving them of their liberty; that the conduct of the perpetrator must be a part of the widespread or systematic attack targeting the civilian population. Thirdly, that the perpetrator must have knowledge that the conduct is a part of such widespread and systematic attack targeting a civilian population. The similar elements are underlined under the ICTY and the ICTR provisions for enslavement. Lack of consent is not considered as an element for the determination of enslavement under the International Criminal Court, and this makes an important departure from the statutes of the two tribunals. The fourth crime against humanity here that I would like to discuss is deportation. This refers to the forced evacuation of whole or part of the civilian population from their homes to other areas. Under Article 72D of the ICC, deportation means forced displacement of persons through coercion or expulsion in the areas in which they are lawfully present. In the case Prosecutor versus Kristich, the accused was charged for 3 counts of deportation and forcible transfer. Some 25,000 Bosnian Muslims were deported from Srebrenica and were transported through buses to other areas of Bosnia and Herzegovina. It was stated that both deportation and forcible transfer relate to the unlawful evacuation of people from territories in which they reside. However, it is not that forcible transfers in all situations are unlawful. There might be cases where it is imperative to transfer or displace people in order for their protection or safety. For instance, when natural or man-made disasters occur, then the government can ask people to evacuate their homes and can transfer them to a safe place. But this act will become deportation if they are not allowed to return to their homes once the crisis ends or once the disaster is over. This is given under Article 49 of the 4th Geneva Convention of 1949, which makes it mandatory for the occupying power to undertake partial or total evacuation before it conducts military operations. This is a measure to protect the civilians residing in that area. Moreover, they have to be transferred back to their homes once the hostilities end. The act of forcibly deporting someone requires a high degree of organizational planning and preparation. Forced deportation does not have to be done through physical violence and can be done either through threats of force or coercion, which can be acts such as detention, whether real or imaginary, duress, psychological or physiological oppression, or abuse of power of such persons, or taking advantage of a coercive environment. The test to determine whether an act constitutes forced deportation is twofold in nature. The first part is an objective test, where surrounding circumstances are examined to see whether there has been the departure of civilians. The second test is subjective and determines if the civilians did stay, whether they would be in fear for their lives. The fifth crime against humanity that I would like to discuss with you is imprisonment. Imprisonment or severe deprivation of physical liberty is in violation of the fundamental rules of international law. In Cordich and Serkes, the ICTY trial chamber was the first international court to define the term imprisonment. It defined it as a crime against humanity to mean arbitrary imprisonment depriving the liberty of an individual without complying with the due process of law, and advised that it should be a part of widespread and systematic attacks against the civilian population. Sixthly, torture. Torture as a crime against humanity is defined under Article 7(2)(e) of the ICC statute as the intentional infliction of severe pain or suffering, whether physical or mental, upon a person in the custody of or under the control of the accused, except when the pain is inherent or incident in lawful sanctions. The trial chamber of the ICTY in Furunzija laid down several elements of torture from the perspective of armed conflict given by international criminal law. It laid down that torture consists of an act or omission where severe pain or suffering, whether physical or mental, is inflicted upon the victim. The act or omission must be intentional in nature. It must aim at obtaining a confession, punishing, intimidating, humiliating, or coercing the victim or a third person, or discriminating the victim or a third person. It must be related to an armed conflict, and the person involved in the torture process must either hold a public position or must act on behalf of a de facto organ of the state or an authority of the state. In the case Kunarak and others, the trial chamber of the ICTY broadened the definition of torture. It concluded that under international human rights law, there is no requirement of the presence of a state personnel or any other state or authority wielding officer in the torture process in order for the other elements to be satisfied and for it to constitute torture. In Bradanen, the ICTY appeals chamber held that acts causing physical pain amounted to torture even when they did not result in serious injury. In Nalitilik and Martinovich, the ICTY appeals chamber decided that an act causing severe mental or physical pain must be made on a case-to-case basis. Seventhly, sexual violence. There are several classes of offences under the crimes against humanity called sexual violence. Rape. In Prosecutor versus Furunzija, it was stated that rape amounts to a grave breach of the Geneva Conventions and is a violation of the laws or customs of war and can amount to an act of genocide if the requisite elements of genocide are met. Under national law, rape encompasses the element of lack of consent and sexual penetration, depending on which nation's laws are being applied. However, under international law, it has a broader definition. In Kunarak, the trial chamber stated that the rape in international law must only constitute the following: sexual penetration, penetration of the vagina or anus of the victim by the penis of the perpetrator or any object used by the perpetrator, and such perpetration must take place without the consent of the victim. Perpetration of the mouth of the victim by the penis of the perpetrator, where such penetration occurs without the consent of the victim. Consent here must be given by the victim voluntarily and must be a result of the victim's free will. To understand this, it must be assessed in the context of the surrounding circumstances. The mens rea in rape is having the knowledge and intention to cause sexual penetration without the consent of the victim. In the landmark case of Jean-Paul Akayesu, the accused was a burgmeister of the Taba commune from April 1993 until June 1994. He was alleged to have been present when various sexual acts and murders were perpetrated upon the Tutsi civilian population. This led to the killing of 2,000 Tutsis by the local armed militia and communal police. The accused was charged and later was found guilty for 7 counts of crimes against humanity. which included extermination, torture, and other inhumane acts, and also rape, under Article 3 of the ICTY statute. In the case of Akayasu, the court defined rape as a physical form of sexual invasion perpetrated upon a person under coercive circumstances. Sexual violence was therefore broadly interpreted to include rape. Other kinds of sexual violence are sexual slavery, enforced prostitution, and forced pregnancy under the Rome Statute. Under Article 7(2)(f) of the Rome Statute, forced pregnancy is defined to mean the unlawful confinement of a woman who is forcibly made pregnant and with the intention of affecting the ethnic composition of any population or for carrying out other grave violations of international law. The Rome Statute also codifies enforced sterilization and any other form of sexual violence of comparable gravity. A next element of crimes against humanity is persecution. This refers to the intentional and severe deprivation of fundamental rights which contravene international law on the basis of identity of the group or collectively as defined under Article 7(2)(g) of the Rome Statute for the International Criminal Court. Universally recognized grounds of discrimination against the identity or collective group of individuals can be based on politics, race, nationality, ethnicity, culture, religion, gender, and other grounds. In the case Kupresic and others, it was found that the defendant was guilty of persecution. It was held that the deliberate and systematic killing of Bosnian Muslims and also their detention and expulsion from their village, Ahmići, constituted the crime against humanity of persecution. Moreover, it was added by the court that the destruction of homes of Bosnian Muslims and their private property amounted to a gross or blatant denial of their fundamental rights. As this was being carried out with discrimination, it constituted persecution. Next, enforced disappearance of persons. The state is under the duty to protect the freedom of its citizens, and any enforced displacement of a person means taking away such a freedom and amounts to a derogation from such duty by the state. Article 7(2)(j) of the Rome Statute defines enforced disappearance to mean arrest, detention, or abduction of persons by or with authorization, support, or acquiescence of a state or a political body, followed by a refusal to acknowledge that deprivation of freedom or to give information on the fate or whereabouts of those persons with the intention of removing them from the protection of law for a prolonged period of time. This definition is also covered under Article 2 of the Inter-American Convention on Human Rights. The Inter-American Convention codifies forced disappearances as a crime against humanity. The prohibition on such a practice is absolute and cannot be permitted in any circumstance. The basic essence of such a crime is that if it is state-sponsored or state-sanctioned or arises due to state kidnappings, it ought not to be permitted. There is a residual category known as other inhumane acts. These are offences which are perpetrated intentionally, causing great suffering, serious injury to body, or mental or physical health. They may be interpreted to mean any acts which are similar in nature to, for example, murder, extermination, and deportation, which have already been specified and already been discussed in this section. But these residual acts are not limited to the acts which have already been enumerated in the statutes of various international tribunals. They extend to any act or omission which causes intentional physical or mental suffering of the victims. Under Article 7 of the ICC statute, limits exist for the acts already enumerated in the article. In order to establish the level of physical, serious, mental or physical harm, factors such as the nature of the act or the omission, the context within which it occurs, its duration or repetition, the physical, mental and emotional effects it may have had on the victim, and also the personal circumstances of the victim, which makes health, age and sex important, have to be considered. These elements were described in the case of Delalich et al. It is also relevant to see whether the targeted civilians suffered serious bodily or psychological harm due to the acts or omissions of the perpetrators. In the famous ICTR case, Kaishema, the court concluded that when a person is convicted of committing an offence which is covered under other inhumane acts, then that act must be done with similar gravity and seriousness to the other enumerated crimes. This raises the threshold for this residual category to be triggered. Moreover, it must be done with the intention of committing the other inhumane acts and also with the knowledge that the act being perpetrated is within the overall context of an attack. What are the subjective elements required to establish crimes against humanity in general? Under the rules of international law, there need to be two mental elements for the commission of crimes against humanity. These are mens rea proper, in order to commit the underlying offence, such as murder, extermination, deportation, enslavement, sexual violence, etc. And secondly, mens rea of a widespread or systematic practice. The first element that needs to be proved is intent. There must be intention to commit to kill in the case of a murder, or any other intentional element such as the intent to inflict a serious injury in reckless regard of life or personal liberty. In cases where the perpetrator is acting as an agent of a system, it is not necessary to anticipate all the specific consequences of the misconduct. It is sufficient if the perpetrator had knowledge that his act could result in serious consequences for the victim. The second element that needs to be proved is that the agent must be cognizant of the link between his immediate conduct and the effect of the conduct in the widespread or systematic practice which is above him. In Tadic, the ICTY Appeals Chamber held that the perpetrator must be aware that there is an attack on the civilian population and that his acts comprise a small part of that attack. Similarly, in Blastic, it was held that the perpetrator needs to be at least aware of the risk that his act is a part of the attack, and then he makes the attack. When crimes are a part of persecution, then there is a requirement of another mental element, which is a persecutory or discriminatory animus. The intent must be to discriminate, harass, or ill-treat a person or a group of persons, or cause great suffering or injury to that person or groups of persons based on religious, political, or other grounds. This additional element, which is needed to establish persecution, amounts to a special criminal intent. Finally, courts have established that there is no requirement that the perpetrator must have a specific racist or inhuman frame of mind as part of a mens rea. In a nutshell, the subjective element to be established while proving crimes against humanity is not just limited to criminal intention, also requires the additional element, which is the awareness of the broader context in which the crime fits in. This additional element is important to distinguish between crimes against humanity and war crimes. Thank you.